everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah. So, uya matinyana. Uya matinyana. Yeah. Uya matinyana. Oh, uya matinyana. Say, I call you Jireh. Say, I call you.
Good evening, our lovely viewers. This is another Saturday evening, and you are watching us live on BW TV. Welcome to another episode of The Community and the Law, brought to you by BWF Solicitors. I will be your hostess for today. I am Pamela Oakley. Today's topic is how to legalize your stay in the UK. I know that this is very interesting for a lot of you because you know people, or some of you are also looking for ways and options to legalize your stay in the UK, and that's what we'll be discussing today. Once again, I would like to welcome you to another episode of The Community and the Law, brought to you by BWF Solicitors.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BW TV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BW TV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BW TV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the law. So pick up the phone and dial 0208 493 or you can send a text 07950 422780. It's the community and the law. My name is Oreku Frimpon and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Welcome back to another episode of the Community and the Law with BWF Solicitors. For the next 2 hours, we are going to have a very interesting topic on the various options of legalizing your stay in the UK. Um, Prior to talking about this our topic for today, we are going to discuss the nuggets, which was put out this week. The nuggets for the week is what is a separation agreement? So it is an agreement between separating spouses, setting out the terms of their separation that generally relates to financial arrangements. Separation arrangements, no, sorry, separation agreements are usually entered into by parties who are separating but who do not want to divorce at that time, perhaps for practical reasons. In England and Wales, separation agreements are not strictly binding in the event of a later divorce, but the terms of a separation agreement may be decisive in the event of a dispute dealt with by the court, unless the effect of the agreement would be unfair. This is from Radmacher, which was formerly Granatio versus Granatio. So we are going to have our intelligent lawyer, Charles Asma, explain to us what the nugget means.
Thank you very much. Viewers and listeners, today's nugget is important for two reasons. Entering into a relationship with someone where, for reasons, one party may have more assets than the other, or they have equal share of assets. And the other reason is to avoid controversy surrounding how to separate individual assets from the joint assets that have been accrued in the course of that relationship. So there is something we call separation agreement. Some will call it prenuptial agreement. The key thing is, how do we ensure that in the event of separation, our assets can be duly shared among ourselves without interference by the court, for example. And this is usually the case where the parties may not necessarily wait for divorce. So if it's not a case of divorce, which will call for separation of or the share of the asset, or how to treat the financial assets they have, what we call financial settlement, then the parties may have their own plan. And this plan is the separation agreement that they may have in place, or prenuptial agreement. In England, every country has its own approach. But in England and Wales, for example, until this landmark case that we'll be looking at, there was rarely a point for prenuptial or separation agreement because it wasn't taken serious and wasn't binding. And most of the time, you would go to court with your prenuptial issues or separation issues, and the court will tell you that, well, go and sort it out yourself. And therefore, in 2010, the UK Supreme Court came up with a landmark ruling that settled on how to ensure that separation agreement between parties can be binding or can be a decisive factor in sharing or in dealing with assets they held individually, for example. So in this case of Radmacher, you can call it Radmacher. The case of Radmacher and Ganatino is a 2010 family law case, and the court concluded that for separation agreement to have the force of law, some factors must be present. And there are 5 key factors that the court identified. I have nicknamed these 5 factors MP-FAD. MP-FAD. M stands for the fact that there should be no misrepresentation. No misrepresentation. In other words, there should be no lies with the assets that are being shared, talked about. There should be no issue of hiding anything, no misrepresentation. You can't say, I have this with a view to get into the relationship, and it turned out that you didn't really have anything. That will be misrepresentation. So the court says that everything should be truthful and factual, so there should be no misrepresentation. And therefore, if it turns out that there was misrepresentation from either party, then that agreement will not have the force of law. So that's one factor the court will look at. The second factor the court will look at is that there should be no coercion or pressure on either of the parties to enter into that agreement, be it the man or the woman, or if they are both man and man or woman and woman, either party. There should be no pressure or coercion. And therefore, nobody should be pressured into entering into a prenuptial agreement or separation agreement. If it turns out that the other party can prove that he or she was pressured into entering into that agreement, then that agreement will have no force of law. So that's M and P. The second 3 factors, FAD, F-A-D. The F is that all the terms should be fair, and therefore there should be no unfairness, ambiguity in the terms. And so the court will consider whether the terms are fair. For example, if it is agreed that one party will take 90% and the other party takes 10%, and that is going to create problem in the end, then the court will say that the terms potentially were not fair. and there could be some other terms, and therefore the court will make an assessment on the fairness of the terms. If the terms are innocuous or unfair, then it is possible that the court will conclude that the agreement will have no force of law. The next factor, A. A, in a sense that, so we've talked about the no misrepresentation, we've talked about no pressure. We've talked about the fact that the terms should be fair. We talked about the other thing that we're going to talk about as part of the factors is that there should be full disclosure. So full disclosure in the sense that everything that the other party is seeking to make bear as part of the agreement or both parties should be fully disclosed. So you cannot later come back to say that this was part of it or that was part of it. If it wasn't disclosed, then it is likely that the court may not conclude that it had the force of
Wow, thank you.
law.
You're a lifesaver.
The last part is that the parties should have independent legal advice. So the parties should take independent legal advice prior into going into or entering into that separation or prenuptial agreement. And therefore, in England and Wales, separation agreements are not strictly binding in the event that later there is divorce. And therefore, if later there is divorce, then the Matrimonial Causes Act will take its effect. And therefore, the remedies available will accrue from that post divorce settlement or financial settlement proceedings or matters. However, if it is contemplated that there will be no divorce, especially where parties are going into unmarried partnership, there's not likely to be divorce because they are not married, and therefore separation agreement will have the remedy that they will need. If there's divorce, then the divorce proceedings will take over. And so if you look at the nugget, it says where there's divorce later, then prenuptial agreement or separation agreement may not be strictly binding. And therefore, the terms of the separation agreement may be decisive in the event of a dispute between the two parties, where it is necessary to consider how they share the asset involved. And for the court to decide whether the agreement is valid or not valid, these five factors must be present. There should be no misrepresentation. There should be no pressure on either party to enter into that agreement. There should be fair in terms of the agreement. There should be fairness. And the next thing is that parties must take independent advice before they go into that agreement. And the last is that there should be full disclosure of all the aspects of that agreement or the terms of the agreement for it to be valid. This is the nugget for today.
Thank you very, very much, Lawyer Charles Asma. So I hope this helps some of us or those of us who are planning on having a separation agreement. I would repeat the five things Lawyer Asma said, which will make your separation agreement valid. So the first thing he said was that there should be no misrepresentation. The second thing he said that there should be no coercion into entering a separation agreement. The third thing he said was that all the terms of the separation agreement should be fair. The fourth thing he said was that there should be full disclosure. And then the fifth thing is every party to the separation agreement should have received independent legal advice before entering the separation agreement. So thank you once again, Lawyer Asma, for your explanation of today's nugget. Please do not forget to like, share, and comment on today's video. Announce your presence by commenting in our comment section. You could also put down some questions you have, and Lawyer Asma will be very happy to answer any questions you have for us today. The telephone number today is 0208 I repeat, 0208 Our telephone lines are not yet open, but once they are open, you can call in to ask any question you have. We will take a quick break, and when we return, we will deal with today's very interesting topic.
Based in London, we are a dynamic award winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for sticking with us for today's topic. Based on our nuggets, we put out a quiz earlier this week, which is Nana Weissman and Abba Goodhart married in 2020 in Ghana. They moved back to England in 2021. Unfortunately, their marriage fell apart, but they decided to attempt a child separation instead of a divorce. As part of their separation, Nana's lawyer drafted a separation agreement for them. Nana had three houses before meeting Abba. He asked for houses to be put in his name and only made provision for £100,000 lump sum to Abba. Abba signed the agreement without legal advice. Abba filed for divorce in 2024 and applied for property and financial order. Now the question is, can Nana enforce the separation agreement as binding? Our possible answers are one, yes, because it was drafted by a lawyer. Two, no, because they have to share the properties equally. And three, it is binding only if it would not create an unfair situation. This is our quiz question, and we will take your answers later down the line of the program. So please do not forget to send in your answers, what you think the answer is, in the comment section, because we will be looking at it later on in the program. We are now going to look at our main topic for today, which is how you can legalize your stay in the UK and the various options that you can use to legalize your stay in the UK. So we are going to speak to our learned lawyer, Charles Asma. He's going to take us through today's topic. Lawyer Asma, can you please tell us the various ways we can legalize our stay in the UK? Because this is very, very important for a lot of us out there. We need to know our various options and what we can do to legalize our stay. So can you take us through?
Sure, I can. And thank you, Pamela. Hello, viewers and listeners. Once again, a very good evening to you. We are here on the Community and the Law Show. Today's topic is clear, straightforward, but very, very significant. Significant for two reasons. One, for those who have legal status in the UK, but not permanent yet, and may need to continue to pursue the journey to settlement. The second reason is for those who do not have any status in the UK, and therefore they want to look at how to legalize. The legalization process is mainly to ensure that you have regularized your status so that you have something that you can use to work, to open an account, to travel, and to live your life without any restriction from any law enforcer. We are going to look at the immigration rules and how the rules will assist in ensuring that you've been able to legalize your status. Our focus is somebody who does not have status at all, what we say undocumented resident. Now, for you to be documented, you have to make an application. The question now is, what options do I have if I seek to apply for immigration status whilst already in the UK? The law allows for different pathways. We have family pathway, we have private life pathway, and we have human or humanitarian pathway. All these are rights that are enshrined in the European Convention on Human Rights, and therefore these applications are likely to fall within the human right spectrum, Article 8. It may also be the case that yours may fall under Article 3, Article 2, Article 5, to the effect that if you were to be removed from the UK, you may struggle to survive in the country where you'll be sent to, and therefore you may apply for consideration outside Article 8 provisions. So there are instances where people can apply to remain in the UK, what we call live outside the rules. So it may be that you do not fall in any of the rules because you don't meet any of the rules. However, you are going to apply outside the rules. That is also permitted. And those are for extreme cases where you have no option at all. Then you go to Plan D. So we have Plan A, family life. Plan B, private life. Then Plan C will be on the basis that based on what you have to then consider live outside the rules. And of course, Plan D, somebody will say that on that basis, I want to seek humanitarian protection, asylum. Today's conversation will not cover asylum, and therefore we'll look at A, B, C. A, family life. You are in the UK as a man or a woman, and therefore we are focusing on adults. In the UK, and you've been in the UK, however, whilst in the UK, you have become a parent. If you have become a parent, i.e., a father or a mother to a child, the law says that because of your parental responsibility to that child, that biological child of yours, you can apply to remain in the UK with that child because you have family life with that child. which is your human right. The question is, what right has that child got to the effect that that right will extend to you? And so the child must be a qualifying child. Who is a qualifying child? In the relevant statute, section 117D, the law says that a qualifying child is a child who is a British citizen, a child who has indefinite leave to remain in the UK, a child who has pre-settled status to remain in the UK under EU provisions, a child who has been in the UK for 7 years, either born in the UK and lived in the UK for 7 years, or born abroad, brought to the UK, and has lived in the UK for 7 years. These children are qualifying children. Therefore, if you are a parent and have a qualifying child, you can apply to remain in the UK on the basis of your parental responsibility for that child. Here we are going to look at it from two dimensions. We have a parent who does not live with the child, but this parent, even though does not live with this child, plays active role in the life of this child, support the life of the child, the upbringing, development, well-being of the child. And therefore, the decision to grant will be the one in the best interest of the child. Best interest of children assessment fall under Section 1 of Children Act 1989, and also relevant cases, for example, the case of Rasga and others. All that this is saying is that whatever decision that is taken by the caseworker should be a decision that will not affect the child. And therefore, if the caseworker decide not to give you the visa so that you are removed from the UK, the child welfare may be affected because your presence in the life of the child is important to the growth, development, and total well-being of that child. And so your refusal may not be in the best interest of the child. And on that basis, you will be given 2.5 so that you can remain with this child. And so you make an application under Appendix FM. We apply for what we call FLRFP. F stands for family, P stands for private. And because this is based on your family, your child, you apply as a parent of a qualifying child. So that is where you don't live with the child. The child lives with the mother or the father, and the other parent plays a role. And here the law says that you have direct access to the child. And in that case, you have to prove that you have direct access, i.e., the mother will confirm or the father will confirm that you play a role. Or you have letters from independent parties, schools, GP, hospitals, what have you, to confirm that you play a role in the life of the child, especially you are the named next of kin or you are the named emergency contact. This will suffice. You support your application with this because that shows you have direct access, together with anything else that confirms that you play a role in the life of the child. So what are we looking at? Photos to show that you play a role, and anything else that you do to support that. And the mother will confirm, or the father will confirm, the school will confirm, the GP will confirm, and that will assist. So that is direct access route, Appendix FM, to legalize your stay. If you have been without papers in the UK and you have a child, there is a chance for you to make an application today or tomorrow. The next one is where you live with the child and the child's mother or father, but you do not have anything. The child has something, the mother possibly has something, or the father has something. Mind you, This is a qualifying child. You want to apply on the basis of your relationship with your spouse or your unmarried partner and your biological child. In this case, the law says that a decision not to grant you leave to remain with your family will bring harsh consequences for the family, the partner, and the children or child involved. And therefore, it falls under Gen 3.1, 3.2, 3.3. And also there's the case of Ajako, which also talks about the fact that separating one parent from the family on the basis that they don't qualify to remain in the UK is harsh, unreasonable, and perverse. And so the decision can be reversed. The caseworker will have this in mind, and the caseworker will make a decision to grant you the visa. That is living with the family as a family unit. That is the option for you. For the other parent who doesn't have leave to remain in the UK and want to legalize or regularize the stay. So we've talked about two options as a parent. You can also, so a parent with biological child, you may also be a parent, but you are not a biological parent to that child. In this case, you may have parental responsibility within the Children Act 1989, where you may have special guardianship order granted to you by the court, or you have been given special support opportunity to be able to ensure that the child welfare is not affected in any way. Or you are in the life of this child because you are married to the child's mother or father. So you are a step parent. Step parent because you are married to the child other parent, or you are a step parent because you and the child's mother or father are in what we call durable partnership. In other words, you are not married to the child at parent. However, you've been in a relationship with this parent for at least 2 years. And therefore, this child has become your de facto child. Even though you are not married to the mother, you're still a step parent. So we've looked at within family route as a biological parent living with the child and the mother of the child or father of the child, as a biological parent with direct access. In other words, you don't live with the child. And also we've looked at as a step parent living with the child and the child's mother. So 3 options there for you. Now we move on to option B or plan B, private life. You've been in the UK. You haven't had any leave to remain. Now you realize that you have spent 20 years of your life in the UK if you are an adult, or you have spent half of your age in the UK if you are a child between the age of 18 and 25 years. The law says that you have formed a private life in the UK. And on the basis of your private life, your removal from the UK to any part of the world will not be fair to you, because you then have to start new life altogether. And so it should be considered on that basis. How do you prove that? I take you to paragraph PL 5.1 of Appendix Private Life. The law is divided into 2 under this part for adults. It says that 20 years, that is A. So you have to show that you've been in the UK, lived in the UK for 20 years without papers. All you need is pieces of documents or papers showing your name, showing address in the UK to show that you've been living in the UK, and showing date to show that within the relevant or material period of 20 years, you were in the UK. You can also even rely on photos, provided the photos have inscriptions at the back not handwritten, but digitalized at the back or front of the photo to show that it was taken in the UK and at a particular date and time so that you can assess whether they fit within the 20 years material period for consideration. This is private life for adults. If you're able to prove that, you can apply for 2.5 leave to remain under the 10-year route. And the law says you must be granted because you meet the 20-year rule. What other evidence can you provide? You can provide even pay slips. If you have lived in the UK, worked under your name, even though you were working without right to work, but you have evidence to show that you have pay slips. The law says that you have breached the rule for working without right to work. However, you are not telling the authority that you haven't worked. You are telling the authority that you have been in the UK, and the piece of evidence, which is payslip, suggests that your name is there, the date is there, and there's an address to show that it was issued in the UK. That is evidence of residence. Even though you are giving yourself up, you are not giving yourself up for them to punish you. You are simply telling them that, yes, I might have worked illegally, but through that, I can confirm that I have been resident illegally in the UK for 20 years. And so I qualify to be granted 2.5 leave to remain under 10-year route under provisions of Appendix Private Life, paragraph PL 5.1A. Now, what about somebody who hasn't done 20 years in the UK? Or somebody who is a child but hasn't done half of age in the UK? The law says that if you haven't done the required number of years in the UK, you need to show that with a limited period in the UK, there is a top-up issue. I call it a top-up issue, in that top-up will make it adequate for you to be granted 2.5 under private life. And what is the top-up issue? The top-up issue is that if you are not granted 2.5 because you have not lived in the UK for 20 years, your removal from the UK will not be reasonable in the sense that you have insurmountable obstacle. This is a big phrase. It simply means that if you are sent away from the UK, you are likely to die. Why are we saying, or you saying that you are likely to die? Because you have a medical issue so serious that if you are removed from the UK, you may not be able to get the treatment required abroad or in your home country, and that will create death. Or you have involved in not involved per se, but you have changed your sexual orientation, and therefore you are a lesbian or you are gay. And on that basis, the country where you are going to frowns upon that. And because of that, your culture in that country and the laws in that country suggest that should you find yourself in that country with this lifestyle, you may not be able to survive. There could be persecution. And therefore, on that basis, you can assert that there's insurmountable obstacle. You have to prove this insurmountable obstacle. For children who are over 18 years, but under 25 years, they have to, I say children because even though the person is over 18 or 18 years, they may still not be leading independent life. However, they are not under 18 for them to qualify within the provisions of Section 117D, and therefore they cannot be qualifying children themselves. Because if it's a person, it's a child, after 7 years or upon 7 years in the UK, they can apply for indefinite leave to remain. But there's somebody who is not a child because they are 18 years or 24 years or 25 years. The law says that if you can prove half of your age in the UK, you can be given 2.5 under private life. The same applies if you haven't done half of your age, but you have insurmountable obstacle awaiting you that may affect your survival in the country where you are likely to be sent to. So we've covered up to option C or plan C. The next option is the one under live outside the rules. Live outside the rules means that you do not qualify as a parent. You do not qualify for all the ones we've talked about as a parent. You do not qualify private life, but you have to be considered for leave without applying any of the rules. And with that, you have to show that there is extreme insurmountable obstacle which may prevent your survival abroad. And in this case, you can say that it's similar to private life without 20 years. We now move on to partners. This time you are not a parent, a partner, and so back to family life provisions. Whilst in the UK, you meet a wife, you meet a man or woman, and you form a relationship, and you want to apply on the basis of this relationship. So here there's no child. So both adults, one applying to remain with the other. That means the other one should be a qualifying partner. Partner is defined under paragraph 6.2 of the immigration rules as somebody who is in a relationship with another, and this person is married to this other, so marriage. Or somebody who is in a relationship with another, but the person is not married, but they have been in that relationship for 2 years. However, they don't live together, they live apart. The law says that you can apply on the basis of that partnership or being a partner. What here we're looking at is the other partner should be a qualifying partner, British citizen, or someone with indefinite leave to remain, or somebody with pre-settled status under EU rules. And that qualifying partner can sponsor your application to remain in the UK with them on the basis that, one, you are able to prove that this is a genuine relationship and that this relationship is still subsisting. If it's genuine, you have to show, of course, somebody will say, I have a marriage certificate. Yes, the marriage may be valid, but it doesn't mean that it was entered into for marriage. And therefore, if it is taken or concluded by the caseworker that this relationship was entered into with the view to take advantage of immigration opportunities in the UK, it will be concluded that this is a marriage of convenience. However, the law is clear. The Secretary of State or the caseworker must prove that this is a marriage of convenience or a sham marriage. What they can do is to invite you to attend marriage interview, and you have to pass the interview for you to convince them or for them to be satisfied. What if you don't pass? It's a discretionary assessment based on the answers you provide to the questions. If you don't, it's likely that you'll be refused. You'll be refused that it's a sham marriage, or you may be refused that, yes, if your partner loves you so much, they should follow you to your home country so that you continue your relationship there. So these are the bits. And therefore, in assessing the merit of your case, the advice will be that because of this, because there's no child involved, the caseworker is likely to tell you this, and therefore you may not have high chance of success. But even if you have 1% chance, it is worth testing it because you may be able to succeed with that limited chance. These are the options. I'll pause here for host to say a word. So, whilst we continue with this, we have looked at the various parameters.
Thank you very much, Lawyer Asma. Thank you. So, just to say a few things or ask a few questions, you are saying that some of the options are as a parent of a qualifying child. So, there are some people who will not necessarily understand what you have said as qualifying child, although you have explained what a qualifying child is. I just want you to like clarify that it's not just any child at all that can be a qualifying child for the purposes of legalizing your stay. That's what you are trying to say. Is that right?
That is the case. And therefore, you may have three children or two children, but one may be without leave to remain in the UK. And therefore, so classic example, you have a child. The child has a father who is British. That child will be British because potentially the child was born at the time the father had indefinite or citizenship. And so, under Section 1 of the British Nationality Act 1981, that child is a British citizen. So, that is a qualifying child because the rules
Okay.
say that a child who has British citizenship. So, you ask yourself, is my child a child who is a British citizen? Or is my child a child who has indefinite leave to remain in the UK? Or is my child a child who has EU pre-settled status? Or is my child a child who has lived in the UK for 7 years, whether born in the UK or brought from abroad, but they have lived for 7 years in the UK? If these factors are present and your answers are yes to one of them, then you can rely on that one to make an application because your child is a qualifying child.
Qualifying child. Okay. So another question, just in case you do have a qualifying child, but you do not live with your qualifying child. You see your child often, you help in the day-to-day raising of your child. There are few people who don't know that you can still make an application based on that child, that qualifying child. So can you just like explain further that if you have access, direct access to your qualifying child, you can make an application to legalize your stay as a parent?
Yes, you can. And I will say that you have 90% chance of success. I say 90% because the caseworker may also have 10%. But how do you prove, as I have already said, show that you are the father of the child? How do you prove that you are the father or the mother? I take you to the 1989 Children Act. The relevant section of the law, Section 3, Section 4, and other relevant sections, will tell you that to know who a parent of the child is, the first port of reference will be the birth certificate. The birth certificate will show the mother and the father. And so the mother, the named mother is the mother, and the named father is the father. Case closed. Should there be DNA? DNA is not compulsory, and therefore nobody can force DNA on you. However, in the event that two parents are fighting parental right or ownership of one child, then it's likely that it will call for DNA. So that is something we have to bear in mind. Or the child is your child. The child lives with the mother or the father. And for some other reason, your access to the child is limited because the other parent is not giving you access. However, court has given you access. If court has given you access, then you have Section 8 of the Children Act 1989 right, which is child arrangement order from the court. So if you have a child arrangement order from the court, you can rely on that order, which gives you access to your child. However, to be able to use that piece of paper or order from the court, you need permission from the court under Section 12 of the Administration of Justice Act. So if you have court order for child arrangement, make sure that before you add it to your application, you seek leave from the court or permission from the court to use. That is what I will add here.
Okay, okay. So just another question. I've had this question before. I just want to see if you could help us out with this. So there is a person who is remarried and his spouse's child is a qualifying child. His spouse is on the parent route through the qualifying child, and he just wants to know how he can also legalize and stay. Can he go on the parent route as well with his stepchild?
Thank you very much. The answer is yes, and this is why. It is because as a man or woman married to the other parent of this child, you form a relationship with that child, and the child has become your child in principle, and the law sees you as a step parent. Even if you are not married, but you have lived with the mother of the child and the child, or father of the child and the child, because it could be that the other parent is a father. We also have single fathers, so much as we have single mothers. So I look at both. So that's not a case of only women can have access, men can also have access. So you can be a man living with a child, but this lady who is illegal is married to you, then the child will be stepchild to this mother or this woman. Or this woman has been in a relationship with you for 2 years, but you, this father has a child. Then this person will have access to this child on the basis that they have a relationship with you. There are also instances where somebody has been given guardianship right to look after a child. They are not a step parent, they are not a biological parent, but they have parental responsibility towards the child. Then that person can have access to this child and so can apply on the basis of that relationship or responsibility.
Okay, thank you so much for your explanation. I hope you have listened and you have enjoyed the topic and you have learned something from today's topic. Everybody who has been trying to figure out a way to legalize their stay in the UK, as Lawyer Asma has said, you can go on the parent route, you can go on the partner route. You do not necessarily have to be living with your partner, but as long as you can prove you've been in a genuine and subsisting relationship for the past 2 years, you can go on the partner route. And if you also have insurmountable obstacles, you can make an application as well. So once again, thank you very much, Lawyer Asma, for your detailed explanation on this topic. You have really helped a lot of our viewers today. So please do not forget to leave your questions down in the comments section. We will be taking your questions and Lawyer Asma will be answering the questions you have for us today. Our telephone lines are 0208 493 2345. I repeat, 0208 493 7345. Sorry, so it's 0208 493 7345. Our telephone lines are now open, so you can call into the studio to ask your questions. We would also be looking at our quiz and the answers you think the right answer for the quiz question. We have our first caller on the line. Hello, good evening. Welcome to the community and the law.
Oh, good evening, Pamela. Good evening, Lawyer Asma.
Good evening.
Mepacho, we the Damascene program, but my person will contribute to Kaka. More questions here, Pacho. The person will be a lawyer, mammy.
Okay.
Mepacho, the editor, my person will be a medical farm, by 1 year. Now, maybe I am indefinitely to the other one being a demand and crying to say, maybe the moment, but the person will say, how many years and qualified to make me a British book naturalization among? And I'm the second question. So, My second question, so yes,
I mean, maybe the first question.
Yeah. Can we please answer the first question? We'll get to the second question shortly.
all right, all right.
Thank you.
And see, my first question is, what do you maba? Now, per se, who say, but okay, umba no
Me,
den no mo
me
tie.
pese me pese me time as you say me year independent to me mom. Na pese me time then na me tina ye British naturalization mom. Sorry, na me tina ye British book mom.
Okay, all right. Sisi ano, so you follow a step at one by one. Akwala no sisi and then ask says say we mano indefinite and I say citizenship.
Indefinite ni na me ye ni sisi a January me ye na me pese me hu say me ye wi a years bi da so a me tina ye British naturalization mom ana.
Okay, all right. So we are oh me number from me say akwala no sisi indefinite no wenya then biem because every wom because be ebedu ono na abro na na mbra foforo aye den aba. Nti na meka no ende no may not be necessary or relevant time wa akwala no benya no indefinite no. Nti one step at a time. Enya ne sa. Why?
Okay, but my second question, so me and mom made a visitor visa and buy 9 years ago. And I may worry and I mean, yeah, main catch and I may be indefinitely to remain. Jimmy Pacho, may meet me after me, I meet me and the British at what one I know this year and sweat and
Yo. All right. The same as Obano, but na meka no say sisi ano obra so say obeye indefinite no mpempren ya won. Okay. So the amranoti for now no ubekura indefinite no at least a year. But minim say bia time no a ubenya wo de no na mra no asesa bia mu dia. It's the same as I said about Ubano. Unya wie a from me say sisi amenya mra no asesa anase na etie na the ben na meko akoye naturalization. Why?
Okay, my last question. Me wo 1 month visa wo me ma me tinye tu kwan akwa the US and Canada.
1 month then.
Sɛ me aka me 1 month visa o me DRC card mu a metumi atu kwan sɛ bi a mekɔ US anaasɛ mekɔ Ghana metumi atu kwan.
Okay, all right. Okay. Akwantuo no it depend on baby a wokɔ. Ghana ye wo krom. So we are Ghana ni.
Mpakyɛ sɛ meyɛ dɛn?
So we are Ghana ni.
Mpakyɛ
So wokɔ Ghana, you don't need a visa. Nti ane there you don't have to worry. But so wokɔ US because when you US ni, unless you go British passport ni nti, we be here visa.
mepakyɛ mewɔ visa ne wɔ mu dada na
Yeah,
menni sika a original mede bɛba no
visa bay na
ɛno
wo,
na
visa
aka
bay
1
na
month.
wo. Pacho visa bay which country? Which country?
Canada.
Who Canada visa, or passport mu 1 month ebewu.
Aye.
Okay, I
But
mean,
no, ɛnyɛ 1 month na ɛbɛwu ɛno deɛ yɛbɛyɛ 5 years but UK British wei no BRP card na aka 1 month because I make a maybe me investment na aka 1 month na ɛwu but mebɛsɛ metu kwan ansa na mayɛ a mɛtumi akɔ anaa.
oh, okay. Into we a UK resident. Ukuta 2.5 and as ukuta then.
2.5
Okay,
and aka
right. I
1 month.
mean, a Canadian visa for 5 years. The only risk maybe say a beer. Oh, Mr. Ukuta visa under than two kaya. Obia misa ubia. Because you have na visa. But beer airport to hono airline no may restrict say I can't 1 month back. Into how long and I could do ho. So we could do 1 month to a very risky so major ma wako. And that's a wobako e could do Canadian airport ho. Now immigration visa will say now no other na chance wobako back to UK. Wobaka try say oh me wa visa me the UK. Your visa say e wa he. We dey try one we say oh na ka 1 month pe. Then na chance we be sha ha. We be say akọ back and there kwaji enough. We are now waba. Those are the risks.
Mepakyɛ Matthias.
Thank you very much for your call.
Thank you. My last question is the will be because maybe I'm an independent say after 31st, you know, the any develop in because he used to be up here, visa no. I'm so dear bicho. Say he used to be up here, visa no. After 31st, the end and then log in the pacho. In the meantime, no be that.
Right. Nti ye ano ema nimpa no a nka wo bebisa no won.
The pacho.
Okay, yo. So we are
Very much.
you are welcome. Sir.
Thank you. God bless you. Bye.
Amen. Now, we are e-visa no a card ni nyina be 31st of December 2024. So from 1st of January 2025 no na e-visa no aye automatically active. Eno na wo be ye obi bia. Ti wo be kom akohwe na ekoso wo ho. Bibi nya enkoyi a na waka kire won say bibi a within and spelling ye we entisa no ma ye kama amawo. Omo de akwenya beto ho how to correct mistakes. But once awenya e-visa no immigration officer benya access to that. Obia o SSL ohun visa bia no obenya access. Na wo no wo bisa won say how do you get in? Account no wo na wo create ye. Na so bi no create ma okra email no eba wo ho. Say ko nipa no ho nso a nipa no betumi aboa wo. Nti what you do is wo be log in. Wo sign in a wo be hu bibia e wo ho. Ene ne we e-visa no. Wo be hu mfoni, wo be hu date a wo visa ebewu, ene visa kra wo. Eno na immigration officer enso ebehu so call system no so a. Why?
Okay, thank you very much for helping our lovely viewer. So please do not forget to like, share, and comment on our video. Please share it, help other people to gain some knowledge and also learn from us. We are live on BWTV. And you can find BWF solicitors at 4th floor house 214 to 218 Tottenham High Road at Seven Sisters. It's very close to the Seven Sisters Underground Station. You can come to them with all your legal issues, immigration, family, civil, and they will be glad and willing to help you out. You can also call to book an appointment on 020 493 7340. I repeat, 020 493 7340. So we will take a quick break, and after the break, we will be taking more of your calls and answering the questions you have for us. Please stick with us. Thank you very much.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much for sticking with us. So our telephone number for our reception at BWF Solicitors is 0208 493 7340. I repeat, 0208 493 7340. We have a caller on the line. So, good evening. Welcome to the Community and the Law. What's your question, please?
Good evening, Pamela. Good evening, Lawyer Charles.
Good evening, sir.
Lawyer Charles, my name is Kofi Antubam.
Hey,
Lawyer
Ejantubam,
Charles,
how are you?
can you hear me?
Yes, please. He can hear you.
Pamela, I can hear you clearly, but I can't hear Lawyer Charles anyway.
Antubam, how are you?
Just one. I'm fine, Lawyer Charles.
Awesome.
My only secretary, my main man. Lawyer Charles, firstly, just to thank you guys for all the help you have in the community. You've been doing so great, and I think we all appreciate you guys very, very much. My question is, the first one is about this EU visa that is going on. Let's say if the person is not on an Android or iPhone, and because it's like all that people are saying is about you have to have your ID open on the phone at the airport. And what I've realized is all they need is, let's say, a share code. My question is, the share code is going to be generated on your phone. Let's say when you reach there and your phone is not working, you have the share code in mind, and maybe you've written it somewhere. How long is the share code going to last before it expires? And also, if you don't have any access to the share code, because I've realized one of my guys came from Europe recently, all they needed was a share code. Okay, so if let's say you don't have access to the phone or something, what's going to happen at that time? And my second question is, with this private life.
Sorry, Mr. Antobam, can we just deal with the first question and then move on to the second question?
Okay, Pamela, I always come and then I run away. Anyway, I'll wait.
Thank you very much.
All right. Okay. So, Antubam.
Mr. Asma, he can hear you.
Hello, Antubam.
Yeah, Mr. Asma. I think I can hear you now. Yeah. Hello.
Hello. Sorry, we're having
Hello, Pamela.
some technical.
You are very clear, but Lawyer Asma is very, very far. I can't hear you.
Can you hear me?
Anyway,
can you hear me?
What I wanted to do is to ask the question and then I can hang up and listen on the radio. What do you think about that?
Okay, that's fine.
Yeah. And the second one is, Asma, with this private life living here, let's say the person don't have anything to show because at the end of the day, he didn't associate with any group or no, he has associated with some people, friends, and then they will write a letter to say we've been with him for all this time, and maybe the home office comes back and say we need a proper evidence like from the HMRC, from the bank, from the GP. Meanwhile, this person did never even register with any of these companies, public entities. So, in that wise, what can he use actually, or he has no chance at all to get the 20 years private life visa? And that is it. Pamela, I would like to hang up and listen from the other end because I can't hear anything from her.
Okay, thank you very much for your call.
Thank you, and good for her. Yeah, thanks for having me. Thanks for having me. Bye.
Lawyer Asma.
Okay, right. So the first question was about share code, how long it lasts for. It lasts for 90 days.
E-visa. He said he has realized that they need a share code when you are coming back from traveling. And so if your phone is off when you're at the airport, but you have the e-visa, for the e-visa from the share code, how long is that share code going to last for?
Well, I haven't experienced people. I haven't experienced it myself. Of course, I wouldn't, and I haven't come across people who have experienced it. And Tubam has, and I don't know how those people got around it. However, if you get to the airport and your phone is not working, or for whatever reason, it's lost power, of course, the caseworker has your passport. I mean, the immigration officer will have your passport and the date of birth and other details, and they will go to the system to check. So I don't know why they will ask for a share code before they process you to enter or to remain. I don't know, but I don't think it's a contentious issue as such. Because anybody, when they return from abroad, um, after the deadline, let's say 1st January going, they will enter the details. I don't think they will ask them to provide share code. So I'm talking about, if you have, please share the details with me. Then I will look into it. And if there's the need to find solution for the wider community, we'll do that. The next question, private life. The law is clear. He who asserts must prove. So if you assert that you have, or claim that you have been in the UK for 20 years, you must prove it. Not having it does not, it's not an excuse per se. Yes, we have people who may not be keeping record and so on and so forth, or they lost their belongings and including their document and stuff. Yes, it happens. However, the law says that you must provide 20 years evidence. What you can then do is, as you said, friends and family will provide testimonials. But those testimonials, the law says that they are self-serving evidence, self-serving. So if they are self-serving evidence, they don't really carry weight. They don't go far. So less weight is given to that piece of evidence. However, if you are refused and you were to go to court, you then tell the court that, look, this is me. I've been in the UK for 20 years. Home Office or the Secretary of State has my record. Even though I cannot, it is not for them to prove that I have been in the UK for 20 years. I'm saying that I have lost all my documentary evidence. And these are the friends and family who can vouch. My church vouches for that, or my mosque, or this and that. You put all this together. Maybe once in the UK, you were in school. The document, the certificates, and all that are all destroyed, but the school still exists, and you go to the school to confirm. You have that. You can add that, but to support your appeal claim in court. And the court will tell the Secretary of State that this is what this person is saying. The Secretary of State, you have also information to suggest that this person might have left the UK when they entered. If you have something, can you provide to assist the court? However, it is your case and you must prove it. So if you are applying on that basis and you don't have enough evidence, I'm afraid your application will not be successful. What should you do? You have a choice to just go for it like that, or to wait till you have gathered enough evidence for the next 20 years. But because this is a legal advice, we have to stick within the confines of appendix private life.
Thank you very much. We are picking our next caller. Good evening. Welcome to the Community and the Law. Can we get your name and your question, please?
I apologize me once again, just to clarify about the e-visa thing.
Oh, okay.
It's Kofi Antobam, yeah. The e-visa thing just happened to one of my friends, and he was at Amsterdam airport, and then they requested for a share code. So what they did was to call the Home Office over here to find out, because he has no access on the phone, but they were asking for a share code. So just to share with the community, I think that is what they're going to use, because they requested for the share code, which later on he was able to let somebody access and then send the share code to them. And then they put the share code in and they got her on the system. So just a clarification to the community. I think that's what they're going to use. I don't know if they're going to change. This is just last week.
Okay.
Okay. Thank you, Pamela.
Thank you very much. Thank you very much for the clarification. Thank you. We will now take some questions from our comment section. We have a question from Nana Etiahene. He's asking, please, is the case of a JACO applicable in FLRFP direct access, or is it applicable in partner application only? Lawyer Asma, this question.
Yeah, that's a valid, that's a good point, a good question, because the case of Ajako looks at harshness assessment of the decision and how that implication will be, or how this implication will affect this family. Here we have a child. You have direct access with your child. Can we extend Ajaku to cover that? But Ajaku, first off, confines itself to family unit. And that is where Gen 3.2 applies, a family unit. So where you have a family unit, you're living with a partner, with a stepchild, you're living with a partner, with a child, then who has the effect? The child and the partner. Because it says that if the harshness will extend to the child involved or the partner involved, then we have to reconsider the decision in the interest of those family members. What if the person lives somewhere, they have direct access to the child? Then the person, so the argument here will be that if the person is sent away, would the other parent be able to cope with the child? If the answer is yes, then you may not be able to apply Ajaku test to this, even though you can extend the conversation to direct access from the Ajaku principle. And so if the other party is able to say, yes, I can, then of course we don't need you. If the other party says, I can't, then we need you. And that is why the other party will give a letter to support the claim that you play active role in the life of the child. So you can look at secondary application of Ajaku principle to direct access provisions. Again, for partners, we've said that, yeah, obviously, if the person is a partner, then you are with the person in a relationship akin to marriage, or you are in a marriage relationship. And so Ajaku will apply in this instance.
Thank you very much. Our next question is from Nana Etiahene again. He says, please, in the UKVI account, 3 sections are seen. 1. Personal details. 2. Contact details. And 3. Sign-in details. Personal details is where you find name, date of birth, photo, and identity document, plus add a new identity document. In my case, the personal details section is missing, so no photo, identity document, or add new identity documents. How can I add passport so that after 31st December, I can log in with my passport to travel? What's the possible cause of personal details section or page missing? After December, can I use my expired BRP to sign in? Thank you very much. Lawyer Asma, if
Thank
you
you
could
very much.
help
So
Nana Etiahene with
if
this.
you leave the question on the screen or maybe move it down, it appears that it's cut my throat at the moment. Um, so the first question is, my personal details do not appear. What could be the reason? It could be a technical reason. The next question, how can I add passport? It's possible to add passport. So when you go online, you ask Papa Google. Once you Google, add passport to my e-visa or to my UKVI account, the link will pop up. Then you enter the details. So you follow the process to do that. So you can add your passport to your account if you have changed your passport. What is the possible cause? I think we've mentioned that could be technical issue. After December, how do I sign in. After December, you don't need your card to sign in. You need to go straight to your e-visa account to sign in. So if you look at the first email that was sent to you, or even the second email that was sent when your e-visa account was activated, there is, if you scroll down that email to the end, it will ask you sign in. Once you sign in, you are into your portal, and that is how you'll be able to access your account. So all you need is your email login details and ability to access that email from any device.
Thank you very much. We have another question from the same Nana Etiahene, who asks, please, if one has child arrangement order, do they still need GP and school letters and the other parent's proof of ID?
Thank you very much. Obviously, if somebody has gone through the court process to secure access to the child, there's acrimony or hostility between themselves and the other parent. And so no other parent will provide their ID. So that is no, you won't get it. The next one is, will your name still be with the GP? The other parent will not possibly give your name to the GP for emergency contact purposes or for you to send the child there. So you may not have that GP. How about school? It's also possible you wouldn't have access to school because you may not be able to. However, if the school is aware that you have child arrangement order, then you have your details with the school as person with parental responsibility, and the school may recognize you as such. So they can give you a letter. However, if you don't have school letter, you don't have letter from the other party or parent, and you don't have GP letter, the law says that you must show that you have direct access. Direct access, the court has indicated per the Section 8 order granted, the limit of your access. It may be the case that you have spent time with access or order. So you go to the child or the child comes to you to spend time with you. So the child doesn't live with you, but they spend time with you. That's fine. That is the access you have with this child. However, you need permission from the court to be able to use this document.
Thank you very much. We are taking another question from our comment section from Veronica Kunedu. She says, good afternoon, lawyer. Please, my 10 years route is going to end August 5th, but people are saying anytime I send to the Home Office for renewal, it takes like 4 months, 4 or more months to get it. Please, in this case, when can I apply for indefinite leave to remain? Thank you. Thank you, Veronica.
Okay. Thank you, Veronica. The fact that it delays and you want to do it early does not take away the need to be sure that you have achieved 10 years residence in the UK, which is the continuing residence assessment under paragraph 117B of the relevant statute. Now, how do you assess that? If you're on a 10-year route, you'll be given 2.5, 2.5, 2.5, and therefore you have to check whether you've done 10 years in the UK legally, even though your last 2.5 years leave is not expired. This can happen only when your leave was granted after it has been with the Home Office for some time. And here you realize that there will be delays. And where there are delays, by the time the 10 years is up or your last leave expires, you would have done more than 10 years. And therefore, when you have your last leave, you just calculate from the very first time you had your leave to see whether you've done 10 years already because there were delays. If that is the case, you can apply for your indefinite leave to remain. Again, you were in as a student, you move to this, you move to that, different areas before you settled on 2.5. And therefore, you've done the 2.5 for some time, plus your student days, the leave you had, provided there was no break, then you can still apply for indefinite leave to remain without waiting for the last leave to expire or to be up. And therefore, if you are going to apply, check whether you have done 10 years continuous residence. Otherwise, you'll be granted another 2.5 because you did not qualify for indefinite leave to remain. If you are not sure, please seek further advice. It says that 10 years route is going to end August 5th, but people are telling me, I don't know whether those people work with the Home Office. However, says anytime you send to the Home Office for renewal, it will take 4 months and blah blah blah. In this case, when I can I apply for indefinite, I think it's clear. If you think that you've done and it's going to expire on the 5th, check whether it's expiring, whether it's ending on the 5th for the 10 years. If your visa is expiring on the 5th of August, it doesn't mean that your 10-year continuous residence is up to the 5th. If your 10 years continuous residence was maybe 1st of August, then you are already 10 years. So you can apply without waiting for the 5th of August. So these are the nitty-gritties of your situation. Do the assessment and be sure that you have done 10 years, that you can apply for indefinite. Don't listen to people who may only be making guesses.
Thank you very much. We will take our final question from the comment section from Nathaniel Williams. He asks, please, if you do not mind, can I ask the difference between the share code and e-visa? Thank you, Nathaniel, for your question.
Yes, you can, Nathaniel. E-visa is the one that is replacing your visa. So we have two. I'm going to demonstrate that for clarity. We have the body of the visa and the spirit of the visa. The law is now saying that we are not going to keep the body of the visa anymore, which is the card or the virginal in the passport. We're not going to keep it anymore. So no more body of the visa. Everything is going to be the spirit of the visa, and therefore it has to be online. So you go online and you find your visa. That is called electronic visa, e-visa. Share code. Share code is your visa that has been converted to a code so that that code can be shared with a third party or anybody. So that once the person keys the code into a system, the person will see your visa to assess whether they should give you a job, whether they should deal with you at the bank if you want to open a bank account, or whether they should rent a place for you or to you if the person is a landlord and you want to engage in tenancy or rental of property. So these are the reasons, and therefore, share code is a code that can be shared to tell what visa you have and your rights. E-visa is the visa that is no longer in the form of hard document, but only available electronically online.
Thank you very much, Lawyer Asma. Once again, I'd like to tell you that you can go to BWF solicitors with your legal issues. So immigration, family, civil, they will be willing and more than happy to help you. You can find BWF solicitors at the fourth floor of Anna House, 214 to 218 Tottenham High Road in London. They are very close to the Seven Sisters Underground Station. You can walk in or you can call the reception to book an appointment to see any of their learned solicitors. So you could call the reception on 0208 493 7340. I repeat, you can call the reception to book an appointment on 0208 493 7340. So we have reached the point of our program where we will soon be looking at the answers to our quiz question. So our quiz question is Nana Weissman and Abba Goodhart married in
Pamela,
2020 in Ghana. They moved back to England
Pamela,
in 2021. Unfortunately, their marriage fell apart, but they decided to attempt a trial separation instead of a divorce. As part of their separation, Nana's lawyer drafted a separation agreement for them. Nana had three houses before meeting Abba. He asked for the houses to be put in his name and only made provision for £100,000 lump sum to Abba. Abba signed the agreement without legal advice. Abba filed for divorce in 2024 and applied for property and financial order. Now, the question is, can Nana enforce the separation agreement as binding? One, yes, because it was drafted by a lawyer. Two, no, because they have to share the properties equally. And three, it is binding only if it would not create an unfair situation. This is our quiz question. When we come back from our break, we would look at the answers you think is right for this question, and lawyer Asma will take us through and give us the right answer.
Based in London, we are a dynamic award winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for staying with us and welcome back to today's episode of The Community and the Law. We have one last question from one of our viewers on Facebook, Paul Labby. Paul says, I had my indefinite through the EU. Do I need an e visa? Sure, the answer is no, but let's go to lawyer Asma to explain to you.
Thank you very much, Pamela. So the answer is no. The answer is no because EU visas already are available electronically. E-visa is only for those who have BRP, not BRC. So if it is a EU visa, no e-visa needed. If it is not an EU visa, you need an e-visa.
Thank you very much, lawyer Asma. So we are now finally at the point where we are going to look at the answers you think is correct to the quiz question. So once again, I will read the quiz question and then take a look at your answers. So our question was, Nana Weissman and Abba Goodhart married in 2020 in Ghana. They moved back to England in 2021. Unfortunately, their marriage fell apart, but they decided to attempt a trial separation instead of a divorce. As part of their separation, Nana's lawyer drafted a separation agreement for them. Nana had three houses before meeting Abba. He asked for the houses to be put in his name and only made provision for £100,000 lump sum to Abba. Abba signed the agreement without legal advice. Abba filed for a divorce in 2024 and applied for property and financial order. The question is, can Nana enforce the separation agreement as binding? 1, yes, because it was drafted by a lawyer. 2, no, because they have to share the properties equally. And 3, it is binding only if it would not create an unfair situation. We are now going to have a look at what you think the answers are. We have Kwame in team who thinks the answer is 2, no, because they have to share the properties equally. Amma Boating also thinks the answer is 2. We have Kojo Owusu who says the answer is 3. It is binding only if it would not create an unfair situation. We now have Akosia Asante who also is on the train of 2. No, because they have to share the properties equally. Then Kwabena Mensa also thinks it's 3. It is only binding if it would not create an unfair situation. Ifya Dumako says 3. We've got Kofi Ajeman, who is also saying 3. Looks like nobody's really going for 1. We have 2 and 3. AC Boydi also says it is 2. We've got Yao Apia who says 3. So oh, Kevin Asama also says the correct answer is 2. It looks like our viewers think the answer is either 2 or 3. It looks like 1 is out of the race. We are going to Lawyer Asma to find out if the 2s are correct or the 3s are correct. Lawyer Asma, can you take us through our quiz question?
Thank you very much, Pamela. Yes, so when it comes to separation agreement, the court takes very critical view because it's an agreement between two parties who may not have the same strength in terms of negotiation. And so one may be winning against the other. So the court will have to look at that separation agreement to see whether it is enforceable or unenforceable. What would the court do? The court will look at the ruling or the principles under consideration from the case of Radmacher and Granitino. This is a 2010 UK Supreme Court case. It's a family case where similar situation, and the court concluded that for the agreement to be enforceable or binding, we have to consider 5 things. 1, and these 5 things, I call it MP-FAD. M, in the sense that there should be no misrepresentation whatsoever, trying to hide certain things just so you can have your way from either party. If it is found out that one party made false statement or false representation as part of the agreement, then that agreement will not be binding. Number 2, there should be no pressure or coercion on the other party to get into it, be it the man or the woman who has the upper hand. So if it is Nana or Abba who has the muscle to win in terms of trying to force the other to sign. If you don't sign, I'll show you where power lies. And because of fear, they signed. Then the agreement will not be binding because there was pressure on the other to sign. So we have to show that there was no pressure. Again, the court will consider whether the parties took independent advice before they entered into the agreement. So you cannot have one lawyer advising both of them to go into that agreement. That will not be enforceable. And the next one is that everything about the properties, everything about the assets, everything about the arrangement was fully disclosed to both parties. So there will be no hidden stuff. If it turns out that there was no full disclosure, then the court will conclude that this agreement is not enforceable. And the other is that the terms of the agreement, whether 100,000, whether one room, whether one property, whatever it is, the court will see whether it is fair to both parties. If it turns out that one party was taking advantage of the other, and so there is imbalance, then it is possible for the court to conclude that this agreement is not binding. Therefore, it is only binding if it is concluded that it is fair in all respect, and so there's no unfair situation.
Thank you very much, Lawyer Asma. So our answer to this week's quiz is 3. So the threes have it, the threes won. Sorry to those who chose 2. Maybe next week you'll get the answer right. Congratulations to everybody who chose 3. That is the correct answer. So the answer to this week's question is 3. It is not possible in England and Wales to have a fully binding marital or civil partnership agreement about what will happen on divorce. The courts have indicated that in order for an agreement to be considered fair, the following will be taken into account. 1. Both received independent legal advice. 2. There should be full disclosure. 3. The terms should be fair. 4. Neither party felt pressured. And 5. There should be no misrepresentation. This is from the case of Radmacher versus Granatino, the 2010 case. So, just from our um, nuggets for the week and our explanation from lawyer Asma, we can see that the answer for the question is 3. So we have now reached the end of today's very interesting program. Thank you to our lovely viewers who have stuck with us so far. We are going to go back to lawyer Asma to give us a brief summary of today's topic. Lawyer Asma, if you can summarize today's topic for us very briefly.
Thank you very much. Viewers and listeners, today we looked at how to regularize or legalize your stay in the UK if you do not have papers. The law allows you to be able to apply for consideration. 1, under family life, as a parent or as a partner. As a parent, biological parent, or as a parent, step parent, or as a parent on the basis that you have guardianship arrangement to look after that child. Let's call you a caretaker parent. So you can have 3 streams of parent: biological parent, step parent, or caretaker parent. You qualify to apply on the basis that you have access to that child. It may be that you live with a child or you don't live with a child. It doesn't matter. What matters is there's child involved here, and you can prove your involvement in the life of the child. Then we move on to family and go to private, where we look at your private life. Private life, the law allows that if you have done 20 years legally or illegally or whatever it is in the UK, you qualify for 20 year route application for 2.5-year leave to remain. And here it falls under appendix private life. Please remember that under section 117B of the relevant statute, if your 20 years includes the time that you were in prison, then you are not 20 years yet. So they will remove your days in prison. So bear that in mind before. And again, if you left and came back, it starts from the last time you entered, not when you first came and you came later. So bear that also in mind. If you haven't done 20 years, then you can consider less than 20 years stay plus issues. That will mean that if you are sent abroad or home, you may die. That's a very high threshold assessment, and therefore make sure that your evidence is clear and evidence is supportive to your case. Otherwise, you can also apply on the basis that they have to make a discretionary consideration of your situation and grant you on the basis that you are applying outside the relevant rules. So outside the family life rules and outside the private life rules, you can apply for discretionary leave. In this case, the caseworker will check whether if they don't give it to you and you are sent away, you are likely to die. If that happens, then the conclusion will be you'll be granted leave to remain based on the number of years they think you need to be able to remain temporarily in the UK. You can also apply on the basis of humanitarian protection, which is asylum. Today, we didn't touch on asylum. However, that is also an option for those who are facing persecution. And so they have Article 2, Article 3, Article 5 rights that may be engaged if they were sent abroad. or removed from the UK. These are the points we've raised and the options you have, which are legal, and therefore you can rely on them to legalize your stay in the UK. Thank you for your time and audience.
Thank you very much, Lawyer Asma. I hope this helps each and every one of our viewers. You have now realized there's no need to be afraid, there's no need to panic. There are various options you can use to legalize your stay in the UK. Just look at what is best for you and put in that application, and who knows, you'll be on your path to becoming a British citizen. So, thank you very much for sticking with us. I hope you have enjoyed today's program, and we hope to see you here with us again next week on the community and the law. Same time next Saturday. Thank you very much. Have a great rest of your weekend.